Hey, this is Lee,
I'm Cooper.
and we are going to do probably a slightly longer in brief than usual. We're going to kind of look at the state of some of the defenses that have been raised in commercial leasing litigation, which, the commercial leasing litigation landscape is still pretty new. We're at the end of April. Obviously, there have been lawsuits as far back as this past fall, but it's starting to ramp up. And we're starting to get a sense of what defenses are working, what's not working. For tenants, unfortunately, many of the defenses are not working, but right defense, right judge, right situation. There are some examples of tenants prevailing, and we're going to go through those a little bit. So, I thought we'd talk about three or four of the most off-sided defenses: casualty, impossibility, and frustration of purpose, which are kind of intertwined, and then force majeure. Casualty and force majeure are kind of contractual defenses. You can't claim either one of those without there being a provision in the contract that speaks to casualty or force majeure. And impossibility or frustration of purpose are obviously common law defenses that the tenants have been raising over the course of the last year or so. So why don't we start with the contractual defenses of force majeure and casualty? Totally different arguments, but both can be found kind of in the four corners of the contract. And we'll start with casualty, because there's an event that renders the space unusable. And there's a very kind of standard boilerplate casualty provision in most commercial leases that says if some event, and one of the examples that most leases gives is fire, renders the space unusable, then there will be an abatement kind of proportional to that particular event. And cases have come out different ways on this issue. Back in December, there was a really tenant-friendly decision. It was 188 Avenue A versus Lucky Jab. It was a restaurant case, and the court there found it was in the conjunction of a Yellowstone injunction, so it wasn't decided on the merits, but the court decided that it was probable that the tenant would be successful on the merits on the basis of a casualty argument, i.e. that the COVID-19 pandemic equated to a casualty event and rendered the space unusable by nature of the government shutdown orders, and therefore the tenant would probably be successful in arguing that it wasn't liable under the lease. So it's a good side of the ledger. And then we're going to talk a little bit more about the Gap case, which came down in the Southern District. That decision was this past March, so a little more recently. Cooper, you're going to talk about that case from the perspective of impossibility and frustration of purpose, but Gap also made a casualty argument, and the Southern District shut that argument down and said casualty is a single event, much like fire. Pandemic is not a casualty, and we kind of know this because there's a force majeure clause that deals with these other more sweeping, broader events which the parties contracted for. So this is going to be a running theme throughout this talk, but you have one court, New York County, that says it is a casualty, and that's back in December. And then you have a second court that says the Southern District, it's not a casualty event. I mentioned force majeure. That's obviously a phrase that we hear clients constantly throw around since back in March 2020. This is a force majeure event. That's not a force majeure event. Force majeure typically has to be contracted for. So there will be a force majeure clause in the lease that speaks to the type of event that excuses performance and what the remedy is. The most typical force majeure provision pre-COVID did not allow for excuse of paying rent. It allowed for other breaches due to the force majeure event, but not the non-payment of rent. We're increasingly seeing tenants and landlords negotiating around broader force majeure clauses for the future, understanding that COVID might be not going away. There's going to be different variants. Courts have been looking at this. They've been kind of sticking to what the parties intend to do. And there was a recent Southern District decision actually that looked at a force majeure clause in the context of an auction event. This is in December of 2020, and it said there was no obligation to kind of proceed with the contract because COVID-19 was a force majeure event, and it excused the performance of the company that had essentially been hired to auction off a piece of art. So that's what we're seeing with respect to the contractual provisions. The courts are coming out a couple of different ways with respect to casualty. And I think it probably is notable for tenants that the one success so far was found at the state court level, not in federal court. So just in terms of thinking about where to bring an action, or if you have control over that, so far tenants have found relative to the amount of success, more success in state court. But what about frustration of purpose and possibility, Cooper?
Yeah. So I think just to start off, I think a lot of what I'm going to say is going to be a little bit redundant. I think the overlap is sort of Lee alluded to, the overlap between casualty, impossibility, force majeure, frustration of purpose. They're all they all have sort of common themes, and frequently you will see a complaint which is going to allege all of them because they all sort of have common themes within them. But force majeure, frustration and purpose and impossibility are both kind of common law defenses. They're not contractual. They're not written into the agreement. So there's a little bit more wiggle room and a little bit potentially more room for interpretation. As Lee alluded to, the courts that have looked to these specific defenses have also taken contradictory, have ruled on these in contradictory ways. The Gap case that Lee mentioned came out in, I believe, in early March, and that was a federal court decision. And they looked specifically, Gap was trying to avoid their rental obligations, and they alluded to, or they invoked the defenses of impossibility and frustration of purpose. And the court took a pretty harsh look at those defenses and essentially said that because Gap could still perform in some capacity, because they could do curbside pickup, because they could, have limited customers, because the business, the purpose of the business was not completely frustrated, because it was not impossible for them to, have customers and make money in some capacity. The frustration, the purpose of the lease was not frustrated. It was not impossible for them to perform. So the court obviously found that Gap was still on the hook for its rent obligations. They took a very strict interpretation of what it means to be able to perform under the lease. More recently, though, a state court in the decision of the case is Brooklyn Babies is the tenant. They invoked these same defenses and alluded to the Governor Cuomo shutdown orders, and the court looked at that and said, because the business was not able to bring in customers, the purpose of the lease was frustrated, and essentially forgave the tenant from its obligations to pay rent during that specific period when Governor Cuomo essentially forbid people from entering into the space. So again, as you can see, these are two cases. They are both came out at a similar time, similar causes of action, right? We're not talking about wildly different businesses or different business models. They're both retail businesses. And the two judges looked at them and came out differently. So I think kind of the final takeaway is really that we're still in the very early stages of these types of decisions. We're going to see a lot more action over the coming months. I imagine there will be some. We'll start to see some trends in one direction or the other fairly soon. But at this point, I think it's still probably too early to know, if people have raised those defenses, whether we're going to sort of start seeing them all come in one direction or the other direction.
Yeah, I mean, I think, one other kind of takeaway is it's been a little bit of a roller coaster ride for landlords and tenants. And now with respect to litigation, I think the thought was this is going to be a wipeout for landlords. They're going to go into court and they're going to sue, and they're for the most part going to be successful with limited exceptions, if there's a really good force majeure clause, for instance. But we've seen now a couple of state court decisions, and this might be the tip of the iceberg or it might be anomalies, we don't know yet, that rely on both a contractual provision and a common law defense in very fact-specific situations where they said you are, based on either a provision or a common law defense, you're excused from paying. So again, we don't know whether or not this is the start of a trend or whether this is an anomaly, but for landlords and tenants who are still working to resolve some of these issues, they're in pre-litigation, they're in litigation, there are decisions to kind of be mindful that it really is going to depend on the judge's interpretation of some of these contractual provisions and some of these common law defenses. And for landlords and tenants, could go a long way to whether or not you have success in preserving your defenses moving forward. Hopefully we're coming to the end of work from home. So this is the delightful conclusion to some of these issues that we're all facing. So as litigation ramps up, hopefully we'll have less Zoom from home, more Zoom from office or in person. But good talking to you, and we'll talk more about these provisions soon.